A big day today in the Lynn Haven corruption case. Chief Judge Mark Walker has dismissed some of the case, but not most of the case. So it is on a path to trial. Now, I told you, I thought that Chief Judge Walker would dismiss the entire case. I was wrong. He only dismissed part of it, a big part of it. So Judge Walker issued, to my understanding, issued two rulings. The first one, he dismissed count one, which is the conspiracy count. And this is the second time Judge Walker has dismissed this massive part of the case. So that's out again. And that ruling is public. I'm going to read you Judge Walker's ruling on that. There was another one that is sealed. That one I cannot read you. Nobody knows what's in it. I guess except for the parties involved. And in that, we know that the judge denied dismissing the rest of it. So where does that put the defendants? Where does that put the government? It's interesting. It's more interesting than we've heard so far in the local news outlets, one of which I believe is intimately involved in this whole thing, WMBB. So I'm going to read to you the judge's ruling, which is not 75 pages like I've been reading to you. It's, I think, 13, maybe 12 pages. So it's not too terribly long. And I want to share with you why he dismissed the conspiracy charge. That's hundreds of paragraphs. And then I'm going to talk with you a little bit about it and tell you where that puts the government, puts them in an interesting situation. If, and this probably will now go to trial, that's the odds, it's the path it's going to. There are ways I can see that it wouldn't go to trial, but I think it's going to trial. And that's going to be super interesting itself. All right, let me get to it. I want to share with you and read to you the actual ruling itself right after this.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777. All right, let's get to the post, just a couple posts before this one. This is on this Facebook page, and I'll share with you what I wrote earlier, and then we're going to look at the actual ruling itself. Federal judge denies motion to throw out entire Lynn Haven corruption case, apparently sending it to trial. Chief Judge Mark Walker has dismissed count one, conspiracy, against former Lynn Haven Mayor Margo Anderson and developer James Finch for the second time. This is the second time he has dismissed this massive part of the indictment. But the judge upheld the remaining charges. The defendants had filed a motion to throw out all charges based on reckless prosecution and Sixth Amendment violations, attorney-client privilege. This has been denied today, and the trial should take place next month. Now, there have been news reports saying that the trial will take place on the 26th of June. It will not take place at the end of this month. That was a placeholder date. So that trial date is going to be moved back again, now that we know it is most likely going to trial. We don't know when the trial will be. And I'll tell you why we don't know. It could be next month. It could be later than that. The trial could be later the next month. And I'll tell you why after we go over today's ruling that is available. There's two, one sealed. The defendants had filed a motion. Okay, the government can seek yet another superseding indictment for count one. They could take a third bite at the apple by going before the grand jury again. You can read today's ruling that dismissed count one below, and we'll go over that. But Judge Walker has sealed the ruling that denied the defendant's motion to dismiss the entire indictment with prejudice. My prediction was wrong. After attending the evidentiary hearings a couple months ago, I thought Judge Walker would throw out the entire case. Now, if this leads to trial, and it probably will, then both sides will present evidence that we haven't seen yet and cross-examine witnesses in front of a jury. Clearly, the defendants have more to risk by going to trial. In other words, it's their lives, it's their money, it's their liberty, it's their reputation. But a trial could reveal a world of public corruption beyond Anderson and Finch that has been covered up for way too long. Trial was by far the most interesting possible outcome because it's going to reveal so much stuff, so many witnesses, so many cross-examinations. Now let's together read the actual ruling. Let me see if I can pull this up just right. And that's about right. Look at that. All right, order on motion to dismiss. Remember, 2 rulings today. This is the only one that's public, and this is the one that dismisses count 1. Why did Judge Walker dismiss the conspiracy count? The biggest charge, yet again. I'm going to read it word for word. Arguing that it improperly alleges multiple crimes in individual counts, i.e. that it's duplicitous. That's what it means. Improperly alleges multiple crimes in individual counts. That's what he means by duplicitous. And that word will come up again and again. Defendants Finch and Anderson moved to dismiss the second superseding indictment. The government responds in opposition. This court finds that the second superseding indictment's conspiracy count is infirm. The remaining counts, however, are valid. Thus, defendants' motions are granted in part and denied in part. This court starts with the relevant background. The court has confronted this issue before, count 1, the conspiracy count, the first superseding indictment's conspiracy count as duplicitous. Because that order looms large over the current motions, this court begins by describing its previous order. The first superseding indictment alleged that defendants participated in a conspiracy involving these 5 projects, 17th Street. That Finch bribed Anderson, the mayor, and Barnes, a city commissioner, to support his projects with the city of Lynn Haven. In addition, Finch obtained one of the projects, the 17th Street project, through a bid rigging agreement with other companies, including Company A, that was GAC Contracting. Now remember, what I'm reading you right now are the allegations against the defendants that were dismissed in this sense, that it was all tied into one conspiracy. These are the allegations by the government, all right? So when you read these, I can't say they didn't happen, and I can't say they did happen. We'll find out now when it goes to trial. ECS, Erosion Control Specialists, bribed Michael White, the city manager, Anderson and Albritton, the city attorney, and received hurricane cleanup and trash pickup contracts in return. ECS also submitted false invoices, and when those invoices were paid kickbacks to Albritton. Adam Albritton is the city attorney who has pled guilty and is now a witness for the government. Debris disposal is another one of the projects. Unbeknownst to the city, GAC Contracting employed Albritton. So the city attorney was also the attorney for GAC Contracting. Albritton directed city contracts to use GAC's property to dispose of debris. After a meeting with Anderson, Finch, White, and the owner of GAC Contracting, Anderson directed companies C and D to dispose of debris at one of Finch's properties. Anderson also vetoed White's plan to designate city-owned property as a disposal site and secured state government support for a plan to use Finch's site. At the same time, Anderson accepted things of value from Finch. The final project, or actually the 4th project, World Claim, a public adjusting firm, approached individual A, who is Chris Forehand, a contract engineer with the city, with a proposal. Help us get a contract assisting the city with its hurricane claims, and we'll give you a percentage of whatever we recover. Forehand, in return, approached Anderson and White offering free services from WorldClaim. Anderson and White signed an agreement with WorldClaim using Anderson's post-hurricane emergency powers. WorldClaim, in turn, provided them free or reduced services. Remember, these are the allegations. Rebuild is the final project in question. After Hurricane Michael, the city had to rebuild many of its facilities. Finch bribed Anderson for inside information and to exert pressure on city officials to aid Finch in obtaining the rebuild project at a significantly higher cost than the city would pay through its already planned rebuild project. All right. Now we're going over what the judge is doing here is he's going over the first time that he dismissed count one, the massive conspiracy charge. He dismissed it for a second time today. After a hearing, this court held that the 17th Street debris disposal and rebuild projects were one conspiracy, but that the ECS and WorldClaim projects were separate conspiracies. Thus, this court dismissed the conspiracy count as duplicitous. Responding to that ruling, among others, the government sought and the grand jury returned a 26-count second superseding indictment. The new indictment begins by laying out essentially the same factual allegations as the previous indictment, descending into describing in chronological order each of the 5 projects set out above. Incorporating those factual allegations, count 1 charges that both Anderson and Finch with conspiracy to commit honest services wire fraud. Here's a quote from the indictment. The manner and means of the conspiracy were that the defendant and conspirators used Anderson's public official position as the mayor of Lynn Haven to offer, give, solicit, receive, agree to accept, and accept things of value from Finch, which were offered and provided by Finch to Anderson with the intent that she would be influenced in the performance of official acts. Anderson agreed to accept and did accept things of value from Finch with the intent that she would be influenced in the performance of official acts related to specific matters, to wit, Finch's business interests before, including the 17th Street project, projects under the half-cent surtax contract, and city business for hurricane recovery as specific opportunities arose. All right, those are the allegations. The remaining 25 counts charged Finch and Anderson with honest services wire fraud, theft or bribery concerning programs receiving federal funds, wire fraud, and making false statements in a manner within the executive branch of government. Executive count 26 and each of the other 25 incorporated all 122 paragraphs of factual allegations. This court first addresses defendant's main argument, namely that count 1 is duplicitous because it charges multiple conspiracies in one count. Defendants contend that count 1 is duplicitous because it once again charges that all 5 projects in one conspiracy count. Specifically, defendants argue that the second superseding indictment still lacks facts tying the alleged erosion control services and WorldClaim schemes to one another, and to the 17th Street debris and rebuild schemes. The government replies, quote, neither count 1 nor any other count charges either defendant with conspiracy related to WorldClaim or ECS, and only defendant Anderson is charged substantively with respect to those matters in other segregated counts, end quote. Put another way, the government argues that count 1 only charges conspiracy as to the 17th Street debris disposal and rebuild projects. If true, Judge Walker says, that would solve the problem, but this court cannot accept the government's argument. Count 1 incorporates by reference at least 27 paragraphs that deal solely with either ECS or WorldClaim. Initially, then, it appears that count 1 again encompasses ECS and WorldClaim. Pushing back, the government claims that paragraph 125 fixes any problem caused by count 1's wholesale incorporation of all 122 paragraphs of factual allegations. Not so, says Judge Walker. Paragraph 125 alleges that Anderson agreed to be, quote, influenced in the performance of official acts related to specific matters, including the 17th Street project, projects under the half-cent sales tax, and city business for hurricane recovery as specific opportunities arose, end quote. And then another quote, the participle including typically indicates a partial list, end quote. That is from Black's Law Dictionary. It's the Bible of these guys in the courtroom. The participle including, the word including, typically indicates a partial list. That's how the law looks at that word. So, Judge Walker says, paragraph 125 is most naturally read as containing a non-exhaustive list of schemes. No wonder Anderson's lawyers, quote, did not read and understand paragraph 125 to limit the scope of the charged conspiracy, end quote. One might ask, what other specific matters paragraph 125 refers to? Because count one incorporates dozens of paragraphs of factual allegations about the ECS and World Claim schemes. It is most reasonably read as referring to those schemes. Thus, this court finds that count one again groups all 5 projects together as one conspiracy. Count one is thus duplicitous. Even assuming, alternatively, that one could also fairly read paragraph 125 as limiting the scope of the charged conspiracy, count one is still facially insufficient. Quote, generally, an indictment is sufficient if it, 1, sets forth the elements of the offense in a manner which fairly informs the defendant of the charge against which he must defend, and 2, enables him to enter a plea which will bar future prosecution for the same offense. That's quoting case law. I'm going to read you the rest of this. We're halfway done with today's ruling that is public by Judge Walker that dismissed the largest count, the conspiracy count, in the Lynn Haven case. And I'll read those to you right after this.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm Al Saulene, your Panama City Beach lawyer. 850-215-0628.
It's a hot time in Florida, and my friend Ryan could make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com.
All right, back to this. Count one falls short because it leaves the charged conspiracy scope ambiguous, combining an open-ended list of matters within the conspiracy and dozens of paragraphs of allegations unrelated to matters specifically enumerated on the list. Thus, count one does not fairly inform defendants of the charges against them which they must defend. For the same reason, the superseding indictment also denies defendants the ability to enter a plea that would bar future prosecution, as it is unclear whether defendants, should they enter a plea, would have pled guilty to conspiracy as to the ECS and World Claim schemes. For these reasons, defendants' motions to dismiss are granted as to count one of the second superseding indictment. Defendants also argue that, quote, the incorporation of paragraphs 1 through 22 in each count creates similar duplicity and related Fifth Amendment problems. Fifth Amendment, of course, is the right that prevents you from testifying against yourself, basically. As in the conspiracy context, quote, the key issue to be determined is what conduct constitutes a single offense, quoting case law. Starting with wire fraud, quote, the unit of prosecution is not each individual fraudulent statement or even each individual scheme, but rather each individual wire transmission, again, quoting case law. Here, each wire fraud count charges one wire transmission. Thus, they are not duplicitous. So they stand, says the judge. Turning next to theft or bribery concerning programs receiving federal funds, courts have found that, quote, each payment is a separate violation, end quote. Counts 15 and 16 allege only that Finch corruptly provided a motorhome to Anderson. Indeed, these counts are more focused than count 1, alleging that Finch, quote, did corruptly give, offer, and agree to give a thing of value, to wit, the motorhome, end quote. Counts 15 and 16 are not duplicitous. So what the judge is saying is that the allegations stand and should be heard by a jury. Finally, the false statement that counts are not duplicitous. Quote, the unit of prosecution under that law there, you can see it, is, quote, a single false statement, end quote. Again, quoting case law. Each false statement count describes the single statement charged in great detail. Thus, the false statement counts are not duplicitous. Oh, it's only 8 pages, so look at that, we're already done. An indictment's primary purpose is to, quote, inform the defendant of the nature of the accusation against him. While the vast majority of counts fulfill that purpose, count 1 again fails to do so. And so this court must again, for the second time, dismiss it. All right. So let me tell you where that leaves us in this case. First of all, as I've said before, and in fairness, I was wrong. That's where it leaves me, is I thought the judge would dismiss it all after seeing what I saw at the evidentiary hearing a couple of months ago. What he has done, though, is dismissed the biggest part of the indictment, again, for the second time. And that is the conspiracy charge, which is hundreds of paragraphs. So that leaves the prosecution with this choice. Either they go to trial without count 1, or they go back to a grand jury and take yet a third bite of the apple, hoping to get an indictment for conspiracy on all 5 projects, which they have not been able to do yet. And I don't see how they do it, but they have the opportunity to do so. So here's why I'm telling you that the trial may not happen next month even, because if the government convenes another grand jury, that takes time. And then they go try to convince the grand jury to get the indictment again. And then they present that count 1 again to the judge, that superseding indictment to the judge. The judge has to decide if they have finally gotten it right. So that could take a while. So I don't know what the government's going to do, what the prosecution's going to do. Are they going to go to trial, say next month? Because it's not on the 26th of this month. That's not happening. WMBB should know better than that. There's no way you go to trial on the 26th with all this going on. So again, that's where we're left. The defendants, I believe, would be in a holding pattern right now. They got to wait and see what the government's going to do, what the prosecutors are going to do. Do they go to trial without count 1, the largest part of the indictment, the conspiracy part of it? Or do they go try to secure a third superseding indictment? Now, imagine this. I don't know how many times the prosecutors are allowed to go tell a grand jury that there's a conspiracy, write it up, and have the judge say, that's duplicitous. It's dismissed. It's out of here. I don't know how many times they can do that, but this judge has allowed this prosecutor to do it 3 times. What if the government does it? What if the prosecutors go convene a grand jury and actually obtain? They may not. The grand jury may say no, but usually grand juries, they were actually designed to protect citizens from prosecutors. But these days, they're basically a rubber stamp. So if they do convene a grand jury, the odds are that they'll get an indictment, that they'll get a superseding indictment. They'll bring it back to the judge. And the judge, the last time the government did this, they brought back almost the same superseding indictment, conspiracy allegations. And the judge just said no to that. What if they bring back a third one and the judge says, no? What does he do then? Do they go to trial and the government has egg on its face? Can he dismiss the whole thing at that point? There are still a lot of questions right now. The biggest one is what does the government do? What do the prosecutors do? Do they go to trial without the conspiracy count? Hundreds of paragraphs. Or do they try to go get one, show it to the judge, and pray that the judge finally says that they've tied it all together, that they're showing the wagon wheel and the rim and the spokes, that they all connect, something they haven't been able to do in the last two times. This is amazing. So I don't know. Evidently I'm as good at predicting law outcomes as I am elections, right? But all I can tell you is what I see and where we are now. And that's what I see, and that's where we are now. All right, I want to thank one more sponsor for in AFP Florida, Americans for Prosperity. If you've been looking for a way to do something to help offer better alternatives for families, you should look into AFP Florida. They're the largest grassroots organization in the entire United States, AFP Florida.
Americans for Prosperity is the largest grassroots organization advancing policies that help people improve their lives. AFP Florida seeks to end corporate welfare, expand energy options, and reform education and healthcare by giving people more choices. Sign up today and volunteer at americansforprosperity.org.
All right, I want to take a quick look at your comments and see what you're saying. Let's see. I'm just going to go through these here. Stacy says bullcrap. Dismissed is the most important part. In other words, that count one, the big part there. This is why other official commissioners and other public service servants are milking our system with the good old biting us. They were all tied together. So what happens with those that pled guilty and more than likely cut deals to testify? Well, I think since it's going to trial, they'll be called on to testify. If something happens and it doesn't end up going to trial, I don't know. I think they've already signed their deals. I just don't know what happens with that. But at this point, it appears it's going to trial. We just don't know when. And we don't know if they're going to go to trial with count one or without count one. So I don't know about those defendants. Lee Anderson, that's Mayor Margo, former Mayor Margo Anderson's husband, says this will be the fourth try. The fourth grand jury. Yes, that's what he means. The fourth grand jury, the third bite at the count one conspiracy apple. They've had four. This will be the fourth grand jury. Frank says, 3 times and yet nothing on PCB. Frank, you are singing to the choir, man. To spend all these resources in Lynn Haven when we know there are much, much bigger. Remember, I don't want to get into that. I don't even want to get into that. All becoming a bunch of garbage. Just can't trust anyone in this town. Jody says disappointed. Jody is the one who runs the Facebook page. You can get great information there as well at the Beacon of Bay County. The Beacon of Bay County. I'll tell you where you won't get it is WMBB. What if they find themselves called as witnesses? I want to see that if indeed they were involved in all of this. Mayor Mike Thomas got a free waterfront home. Nothing. Yeah, he got a lot more than that too. I do believe, according to information and belief. That's what they say in court. How do I know? I've been deposed into defamation lawsuits that they lost. But I found out a whole lot of stuff when we put them under oath. All right, that's all I have for you. It's been a big day. Really the defendants have to be, they've had a bad day, right? Because they had a really good chance of this being dismissed with prejudice and it ending. The prosecution also had a bad day. They also had a bad day. They had count one thrown out. And now Judge Walker says, you want to go to trial? You're going to get your wish, most likely. And that means they're going to have to go on the stand and face cross-examinations. And if they go anything like what I saw in the evidentiary hearing, it is going to be ugly. So really nobody had a good day. But the difference is when you are charged with federal crimes, everything's on the line, right? Your life, your liberty, your reputation, money, everything. Government, if they lose, then they lose. Unless the prosecution is so reckless that it becomes malicious and sanctions are issued by the court. Do I think that'll happen? I don't know what's going to happen at this point. But I do believe if it goes to trial, and it probably will, that it's going to be, you're going to see some stuff. And I'll be there. And I can't record it because it's a federal courtroom. Who saw the defamation trial with what's her name, Amber Heard versus Johnny Depp versus Amber Heard? See, we saw that, right? It's on video. That's because it was a state court. State courts, the judge can let cameras in. Federal courts, no cameras. That's when you see the sketches, right? When you start seeing sketches and stuff like the mob, that's a federal court, no cameras. So maybe I'll sketch out some pictures when I'm in there. But I'll be there. Don't know when it's going to happen. I got a feeling it's not going to be soon, though. That's my guess. All right. Listen, if you appreciate my efforts and you want to support my work, here's how you can do it: by becoming a patron at patreon.com/Bernie Thompson. It's kind of like giving a tip for as little as $5 a month. It's anonymous, it's easy, and you can quit at any time. Patreon.com/Bernie Thompson. And as always, I want to thank the Unknown Patriot for supporting the show. The Unknown Patriot. Isn't that great? Used to be the Unknown Comic from the Gong Show. I want to watch the Gong Show. That's what I want to do. Maybe I'm going to go do that the rest of the night. It's about what I need. Thanks for being with me. And I will bring you more as in this incredible story that is bound to get 100 times more interesting. I'll bring it to you when I get it. Thanks for being with me.